at the University of Arizona Law School, and a quick announcement before we move on to our next panel on law enforcement. So for those of you who are here intending to receive CLE credit, there are forms in the back corner by the water station there. So please pick up those forms at the end of this session. So it's the great pleasure of introducing this excellent panel. Speaking first will be Dan Kanstroom from Boston College Law School, followed by John Leavitt, who's a captain at the Tucson Police Department, and Annie Lai from UC Irvine School of Law. They're each going to talk for about 15 to 20 minutes. Dan got a variance from me, so he can go for 20 minutes. And then I'll invite our panelists to respond to each other's comments and then open up the room for questions. Dan?
Well, thank you. It's really an honor and a pleasure to be here. And I'm sure I don't have to tell many of you today is Defender of the Fatherland Day in Russia. So I want to wish you a happy Defender of the Fatherland Day, holiday that may soon be coming to a country near you. We're undoubtedly living in interesting and challenging times regarding immigration law and policy. As the previous panel highlighted, this is particularly true of the relationship between federal agencies and state and local law enforcement. One of the most interesting unresolved questions, as again you heard before, is what might be called the problem of preemption symmetry. And this relates to how we characterize aspects of this phenomenon that was well named by Stella Birch-Elias as the new immigration federalism, along with a lot of other scholarship. She in particular defined this as, quote, immigrant exclusionary rulemaking, which has the potential to complement as well as to occasionally contradict federal efforts at comprehensive immigration reform. And there had already been a rising tide of such initiatives of various types. It was actually not unheard of course, for the Obama administration to challenge certain state and local initiatives that sought to protect people from immigration authorities, especially in regard to secure communities, which we can talk more about in questions. But it's obvious that we're now facing a substantial pendulum swing raised by so-called sanctuary cities and by the various types of disinclination of local law enforcement personnel to cooperate in various ways. As I expect you know, it was a mere 5 days after taking office that President Trump signed one of the first executive orders to attempt to block federal funding from sanctuary cities. And of course, there are many other avenues. I think there's a lot of thought going on in Washington and elsewhere now about how to overcome, override, and otherwise impose the federal will on recalcitrant states and localities. There's also a welter of new state initiatives, most notably in Texas and Colorado, that seek to constrain and override and even punish local initiatives. So we have sort of two versions of the problem. I'm not going to have much time to talk about those initiatives, although I think they're clearly analogous to some of the state-federal tensions, albeit without Article 6 of the Constitution or the 10th Amendment as guideposts. I did want to just read to you a bit from this Colorado law, which is called the Colorado Politician Accountability Act. It's quite an extreme example. It creates a civil remedy against the state or political subdivision of the state and against its elected officials for creating sanctuary policy. It creates a crime of rendering assistance to a, quote, illegal alien, unquote, that can be brought against an elected official for having created a sanctuary jurisdiction. It just gets better and better. Creating it includes voting for it. It also then creates a civil remedy, a tort action, a civil action for compensatory damages against anybody who was responsible for creating a sanctuary jurisdiction. For some odd reason, it's capped at $700,000 per person. I don't know where that number came from. But it allows people who are voting for these things to then be sued civilly in a variety of settings. This, I think, does cross the line, that line between interesting and wacky, and it's unconstitutional for more reasons than I can even begin to discuss. But nevertheless, I don't think we should underestimate the depth of the administration's commitment to eradicating state and local initiatives of this type. Jeff Sessions has written about this, including in a law review article, actually, some years ago. about dramatically increasing state and local cooperation of a certain type. And of course, again, as I expect people know, the recent Kelly memos and other contain, among other pernicious ideas, a type of ramping up of 287G agreements. I don't have time to get too much into the weeds on this, and it is actually a very complicated and somewhat weedy area. What I wanted to do was pose a very basic question, which was mentioned at the previous panel. I just want to focus on it. Should there be any difference in the way that our legal system reacts to state-local attempts to increase immigration enforcement, for example, Arizona's previous attempts at attrition through enforcement, versus state and local attempts that have the effect of resisting, competing, or at least declining to cooperate with federal authorities? In the previous panel, we heard one version of an aspect of this that Hiroshi has argued, have argued that equal protection may be a key concept here. As David noted in his book review, which I thought was quite enlightening about black box federalism, there are many doctrinal obstacles to that. I personally am strongly sympathetic to that line of reasoning, but I'm troubled by the doctrinal complexity, so I'm not going to enter that thicket today. What I want to do is create a different thicket that's more focused on the nature of the state action that we're talking about. Now, I imagine that as you hear this, your first reaction might be that any differentiation of preemption models based on the nature of state and local action, for example, differentiating state and local action that seeks to mirror or aid federal enforcement versus that which ostensibly seems to impede it, your reaction might be negative, because it's certainly reasonable to say what we need is a coherent, consistent, and neutral approach to the Supremacy Clause and the 10th Amendment. But what I want to do is to problematize that idea by offering a model that's less binary and more, I'm going to use the word for this, dialogical. And it requires us to ask deeper questions about the respective nature of both federal and state actions in terms of how they relate to rights and how they relate to certain deep, well-established principles of state law, especially state constitutional law. So here's the provocative suggestion in a nutshell. Federal judges should engage in a more nuanced analysis than has been typical when conflicts between state action and federal immigration enforcement arise. The reason for this is particularly illustrated in so-called crimmigration cases, where state criminal laws and criminal law processes have long been specifically utilized by federal authorities, not only to identify priorities for enforcement, but to define who, among otherwise legally resident non-citizens, is subject to removal at all. And let me just clarify, for those who are not experts here, there are different forms of deportation. There's a form that relates to undocumented people, but there are also tens, hundreds of thousands of people who are otherwise in legal status who have been deported over the past 25 years or so, pursuant to what I have long referred to as our radical social experiment with deportation in this country. So in this setting in particular, and it also may apply to discretionary actions relating to some of the undocumented, I suggest that federal authorities, to a greater degree than has typically been thought true, ought to take, quote, the bitter with the sweet. That's an homage to Justice Rehnquist's dissent in the Loudermill case. My approach to this is similar to that of some others, but let me just suggest that its roots are in the deeply felt and I think correct inclinations of many of the better state and local law enforcement personnel. And I thought I would just give you an example of that with a little clip from the sheriff of Travis County, Austin, Texas, who I think lays out very well what her approach has been and why she is not feeling that she has to comply with all federal immigration detainers, which some people characterize as a violation of law, but she characterized as the better practice of upholding law in her jurisdiction. I hope this works.
I'm Sally Hernandez, your Travis County Sheriff, and I would like to take this opportunity to explain how the Travis County Sheriff's Office will work to keep our community safe and coordinate with federal immigration authorities while respecting the constitutional and civil rights of the residents of Travis County. I want to make it clear the Travis County Sheriff's Office will continue to work with all fellow law enforcement agencies, local, state, and federal, We will also continue to honor all lawfully issued warrants and hold those inmates for our fellow officers in law enforcement. I'm committed to public safety. Under the previous detainer policy, an inmate who was charged with a crime was deported as soon as he posted bond or before his court date. As such, the inmate never went before court, the victim and their family never had a day in court, and the inmate's criminal record would grow. This system does not foster public safety. Public safety is fostered whenever there is accountability and closure. Being committed to public safety also means that I will do all that I can to ensure victims report crime and witnesses cooperate with Travis County deputies. The Travis County Sheriff's Office must enact policies that build public trust, including policies that make it clear that as local law enforcement officers, we will not interrogate or arrest someone over an unrelated federal immigration matter if they are trying to report a crime. The public must be confident that local law enforcement is focused on local public safety, not on federal immigration enforcement. Our jail cannot be perceived as a holding tank for ICE or that Travis County deputies are ICE officers.
Actually, I'm going to stop it there because I am concerned about time, but I think that gives you a good insight just in terms of the repetition of certain themes about public safety, public trust. Travis County deputies are not ICE officers, we don't, etc. It's interesting to note in the complaint that the city of San Francisco filed against the Trump administration, which is seeking an injunction against withholding of federal funds against San Francisco. Paragraph 9 of the complaint says, this lawsuit is about state sovereignty and a local government's autonomy to devote resources to local priorities and to control the exercise of its own police powers. In paragraph 22, it says, importantly, these chapters do not protect criminals or prevent people from being prosecuted for illegal acts. Instead, they protect children by ensuring that their parents feel safe taking them to playgrounds, to schools, and to hospitals. They protect families from being split up when parents of children born in the United States are deported, and they protect the safety and health of all residents of San Francisco, and so on. So what is this all about, and what does it mean doctrinally? I want to suggest that these inclinations, and some of which are sort of rhetorical flourishes, do have real doctrinal weight in certain situations that have arisen and in others that are likely to arise. They arise clearly in three specific types of state and local action that might well be deemed non-cooperation by, say, Chris Kovach or others. These are, first, as you saw, resistance to federal immigration detainers, which, after all, are not mandatory requests anyway, which we can talk about in the Q&A. Second, state diversion programs that may implicate what counts as a conviction for immigration purposes. I'll explain that a little more in a minute. And third, state post-conviction, after conviction adjudications that address an array of legal and constitutional claims, such as the retroactivity of Padilla claims and things like that. So when a person is convicted, they may seek to vacate that conviction in part to avoid immigration consequences, but they do it on the basis of state constitutional law. In Massachusetts, we have a principle known as the interest of justice standard, for example, that has long history in Massachusetts, a state which actually has a constitution that long predates the federal constitution. As another example, California recently made retroactive a law that provided that all misdemeanor crimes have a maximum sentence of 364 days. That was done to avoid certain types of immigration consequences, again, which we can talk about the details, but largely to avoid so-called aggravated felonies, which result in fast-track deportation, lifetime banishment, and the dismissal of any kind of claims for mercy or ameliorative discretion. So if this law, the California law, for example, or others, were challenged on preemption grounds, or if federal agencies sought to disregard it somehow and not to recognize it, which is a well-worn path in immigration, what might be the best counter-arguments? And as we've heard, equal protection sort of orientation is one, but I want to offer another way of thinking about it. The basic idea, to reiterate, is that it is a starting point, not a detail, not an afterthought, but a fundamental idea is this, that the federal use, substantively and procedurally, of state criminal systems as part of immigration enforcement is a long-standing reality and should be a two-way street. That is to say, respect must run both ways. This is different from SB 70, where the state was clearly, in my view, trying to implement immigration law in a variety of ways. So I want to be clear about what I'm saying here, and certainly not to deprecate or disparage rights claims that are implicated here, even though this is a sort of structural approach. I think the rights claims have always been a major part of what we're talking about here, going back to the Alien and Sedition Acts of 1798, where you had structural claims that were made by Jefferson and Madison about states' rights that have, I think, rightly been relegated to the post-bellum ash heap of history. But some of the underlying rights arguments, Jefferson's famous concern about, for example, the friendless alien standing as the victim of a social experiment, which he wrote about in the Virginia Resolution, still resonate, and I think for good reasons. Old cases that challenged aspects of the Fugitive Slave Act of 1850 offer similar examples. The opening argument in the Abelman versus Booth case in Wisconsin, which was a challenge to the Fugitive Slave Act, which had authorized federal marshals to arrest alleged fugitive slaves and federal commissioners to adjudicate their cases, put it this way, quote, "I hold that it should rather be regarded as a peculiarly happy feature of our institutions that there is a medium ground, and that when the evil spirits of usurpation and oppression enter into and possess the federal power, the states may interpose, with powers as they have, to arrest the progress of evil, and to avert, if possible, the necessity of the last resort to the terrible ordeal of revolution." Of course, we're not close to that. The same reasoning that proves the right of the people to that last resort proves still more strongly their right to avail themselves of every means of protection from state government. As the judge who decided that first case put it, states will cheerfully submit to the exercise of all power and authority by the federal judiciary, but they have a right to insist, and they will insist, that the state judiciary shall be and remain supreme in all else, and that the functions of the federal judiciary within the territories of the states shall not be transferred to subordinate and irresponsible functionaries. Every jot and tittle, there's an expression you don't hear much anymore, delegated to the federal government will be acquiesced in, but every jot and tittle of power reserved to the states will be rigidly asserted and as rigidly sustained. That's essentially what I'm talking about. And this is further, the judge went on, it is only by exacting of the federal government a rigid conformity to the prescribed limitation of its powers, and by the assertion and exercise on the part of the states of all the powers reserved to them, and a due regard by both to their just and legitimate sphere, that obedience can be rightfully exacted of the citizens to the authority of either. Now, the Supreme Court did ultimately rule the other way in that case. I am aware of that, but that was Justice Tawney, and it was a couple of years before Dred Scott. Anyway, time flies, so let me conclude. There are two aspects to what I'm suggesting. The first, essentially, is the bitter with the sweet idea, based upon the extensive federal reliance on state criminal systems, both procedurally and substantively. Put simply, since the beginning of the modern deportation regime in the early 20th century, vastly more people have been deported for violating state criminal law than for violating federal criminal law. The second aspect is more subtle, and I call it this model of dialogical federalism, harkening back to early work of Bob Cover in particular, and more recent work by Judith Resnick, Robert Shapiro, and others. As Cover noted in a piece that he actually co-authored with a very young Alex Aleinikoff, once we reject both, quote, a hierarchical imposition of federally determined values, quote, end quote, and, quote, a model of fragmentation justifying value choices by the states, end quote, we can recognize that conflict and indeterminacy are not necessarily dysfunctional. Indeed, they may be productive. Values may evolve into rights, as this is not them, this is me. Values may evolve into rights as lawyers fight about their implication in various settings. Conflicts will arise, of course, as values are interpreted differently by the two court systems, but if federal courts can avoid imposing a solution based on crude and blunt preemption doctrine, then an open-ended dialogue can ensue. And in that way, this dialectical or dialogical federalism that emerges can be a driving force for more sophisticated and more legitimate articulation of rights that straddle this intertwined state and federal immigration systems. So the essential conclusion is that the state enforcement agents and state courts are deeply engaged in immigration processes already. This engagement implicates normatively powerful sub-federal systems, such as criminal law enforcement, retroactivity analysis, and so forth. The best state court decisions, and I can cite some from Massachusetts and some from other states, balance state autonomy, fidelity to state precedent, and protection of rights with awareness of federal concerns. There can be no precise formula here, but the sophisticated, nuanced state court adjudications help federal courts when considering preemption challenges to resist formalistic and unrealistic field preemption or plenary power preemption. The benefits of this dialogue could be substantial, as state courts can help to develop transformative and rights-protective models of immigration federalism. Thank you very much.
So good morning, I'm John Leavitt. I'm the captain of the police department. I started law enforcement here in Tucson in 1982. I'm a Tucson native. My wife is a Mexican-American and a Tucson native. Our children are fifth generation Tucson natives. We've experienced, I think, a really long-term relationship with immigration and immigration law changes over the last 20, 35 years that I've been involved in law enforcement, and I've been able to see that, kind of a front row seat or a backstage pass to how that works. I did have 131 PowerPoint slides I was going to show. I'm going to ahead and defer to Dan because he had a video that I thought was probably of greater value. I want to talk just for a minute about straddling that line between state and federal law and sort of the problems and opportunities that it presents, because it does. It cuts both ways. And I'll say, there's a lot of talk about discretion here today, and discretion is perceived, at least in what I understood, and maybe I took it too literally, as ending up delivering a racially disparate impact more often than not. And I hear that. That's not my experience, and hopefully, over time, that will be borne out as being truth. I think people that have had, again, my 35-year experience with that is that's not true. And I'll talk a little bit about that. So, the Arizona law didn't allow a lot of discretion when it was passed, and we have several masters. In law enforcement in Arizona, at the local level, we certainly have the Arizona law, we have the federal law, we have the community groups that we serve, we have the people we live with, our own families who live in the community, we have the city council, we have a whole range of people who we have to try to satisfy when we figure about how to go about enforcing the law. And in this case, everybody has a different perspective. There's no two groups there that I mentioned that had the same perspective. So over the last several years, particularly since 2011, we've had this constant moving policy change, training change, new policy change, training again, supervising, training, supervising how to supervise a new policy change, training, new policy change, and a change in legal advice. And that was October 12th, we changed our policy to take away the lack of discretion on certain kinds of cases and add it back in. And so, the result of that, it's 30 months, 2.5 years prior to October 12th, we contacted Customs and Border Protection 194 times. Actually, we called 43,000 times in that period of time. They said they would come 194 times. They actually showed up 119 times. That's in 30 months, okay? 119 times. And of that, so that's how many people were actually involved. A lot of people in Tucson, a lot of people in immigrant communities think we, through the work of local law enforcement, deport 7, 10, 15, 20 people a day. It's not true. That's 30 months. That's 119 times that they showed up. And so, since October 12th, when we had this policy change, when we added discretion back into the question, and that had to do with accepting identification as sort of prima facie evidence of citizenship, certain kinds of identification, we called 89 times, 189 times, they showed up 7 times, and it took 7 people. So 7 people in the last 4 months, that's, those are It's important to those 7 people, but those are the actual numbers. So the issue that we have to deal with, though, is we're policing in a community where we have a huge number of people who believe this is something that's going to threaten their ability to live and work and learn and do those kinds of things in Tucson every day because of maybe the unsettledness of the law and the discussion that surrounds all of that. And the truth is, they do live in terror. They absolutely do. And I don't know if I think everyone here probably has deeper knowledge than your average person does about how that affects our ability to do child abuse investigations, whether or not child abuse actually gets reported to us. There's a large chunk of America that thinks that people who are here without proper documentation all live together in the same place, and they don't interact with other people. But of course, every house we go to, there's a mixture of people in a variety of different legal statuses, and we go to do those kinds of things, and there are absolutely cases of domestic abuse, child abuse, and countless other crimes that never get reported because people have this fear of being deported or having their cousin deported or their brother deported or whatever. And I guess what I'm trying to say is it rational for them to have that? Well, of course, because that's all they hear. There isn't anyone telling the other side of the story, not that we have to, but that's one of the unintended consequences, I think, of the debate, is that these people really believe they're at risk. And I'll say that, how do we get involved with these people? The beginning of SB 1070, which is not actually SB 1070, as you all know, it was replaced by a House bill a few days later. The beginning of that, and for months, and still people report, and it's, people say, well, don't pay attention to the media. Well, everyone else does. That's what creates the terror, I think. They report this show me your papers thing. Well, that doesn't happen. That's not the way it works. Are there some rogue people who do that in the world? Yeah. But in any profession, in any line of work, that's true. But the truth is, if you knew the law and you read the law, you knew that's not what it said, based on reasonable suspicion. So all those people that we came into contact with, how do we come into contact with them? Fully half of those people are the result of a 911 call, where someone wants us to come solve a problem in their house. Well, thank God they're calling us, because of all those issues that we talked about. And 35% of them are on traffic stops, where we encounter someone in a traffic stop. In the last couple of years, since we started collecting this kind of data, to be able to do an analysis of this, a lot of that had to do with driving and suspended licenses, the driver's license issues, those kinds of things. And the Arizona law, as you pointed out earlier, the Arizona law that requires you to have picture identification if you're driving a car, even if you don't have you can drive without a license as a civil offense, but if you don't have picture identification when you drive, then it creates a criminal offense. And so there's a whole bunch of issues that come out of all that. So I don't want to see the problems overstated, but I want to say that it's not what people think it is. And it is really hurting our ability to police the community when our community members believe that we're involved actively in immigration, and in immigration enforcement we're not. And were we ever? Yes. Yeah, we were in the 80s. I can tell you we participated often with our federal partners and did something called Operation Whistle Stop years ago, where they'd stop the train coming up here out in the desert, and people would be taken off the train and deported. But that's not the way it is today. That's not the way we are today. So I would also want to talk just a little bit about police officer motivation. So there's, like it or not, you don't promulgate rules at the top and push them down and have them do that when it comes to discretionary enforcement activities. That just doesn't work. In fact, if you say to someone, you cannot write traffic tickets for loud mufflers, you can pretty much guarantee you will get loud muffler traffic tickets for the next 6 months. And if you say you have to write those tickets, you'll get none. You just get none. And it's because you say, well, that's because they're obstinate or they're acting like shit. It's not. It's because they really take this discretion thing seriously. Police officers are here for the vast majority of them are here because they want to help people, they want to solve problems, and that's what they're here for. And they really don't want people on high telling them how they're going to take a general rule and apply it without discretion to a fact pattern that those people haven't seen. And everything is fact specific. Every situation we run into is just a little bit different. And so police officers really resent that kind of direction. And you figure that out over the years. And so some people say, well, that's bad. It shouldn't be that way. Well, I disagree entirely. I'll use my experience dealing with race issues, and I know Annie worked for the ACLU here in Arizona, and she knows our reputation for what we've accomplished and what we've done in the Tucson Police Department in that regard. And I'll say that when I started in 1982, I was unequivocally trained by the people at my academy, and was not allowed to say this for many, many years. I was trained that if you were developing reasonable suspicion and you saw someone walking through an all-white neighborhood and they were black, that constituted reasonable suspicion. I was trained that way in 1982. Now, I had the good fortune over the last 35 years to go and check in on how that training has changed. And when I assumed responsibility for our race response, and racial profiling response in the mid-late 1990s, that wasn't the case. In fact, the training that we offered people was quite to the contrary, and quite today, very progressive, and excluding race as following the law. And so I tried to figure out where that happened, how that happened. Because we didn't have a consent decree, the Attorney General didn't tell us to do it, no chief ordered it done, no commanders really cared, and it's organic. It's exactly what Joshua was talking about earlier. It came from the bottom up. Who does training in police departments, training that's effective? Police officers that have an interest in a particular area become a subject matter expert at the state level. They go through, they develop curricula, they send that through a process, gets approved, sort of gets evangelized, it's okay to use that word, right? Around the state, other people pick that up. So police officers change the rules for developing reasonable suspicion, independent of every other influence. They did it without their bosses even knowing over a long period of time to reflect what is a very progressive policy today. And I've seen that time and time again, and that's, I think, something that people don't recognize and I think it could happen here. So, I don't think their motivation is bad. I think the motivation is you give them discretion because they're dealing with fact-specific problems. And if you look at the system as a funnel and we're the beginning of the funnel, if we screw up and we put the wrong people in the beginning of the funnel, I've never seen it get better for them. I'll tell you that as they move through that, specifically in disproportionate minority confinement issues, when you look at that funnel and how people go through the system becomes more and more oppressive on people of color. And all I can say is, if we can do something at the beginning to try to keep the wrong people out of that funnel, then we ought to be doing it because it really helps everybody. So we have this special responsibility, I think, to be very, very careful about how we exercise discretion. But I don't think that it is either unwittingly, implicitly biased, or I don't think it's racially biased. I think the vast majority of people are not acting in that sphere. So that might be an exception to what some of your other experiences are being, but this is, sort of a 35-year look back. The one area that this is, another area that's creating real problems in our inability to develop sort of a coherent approach towards immigration law that's consistent or whatever is, and the term that's used, and I don't like it, it's called clutter on the border. I had the experience of flying the entire Arizona border in a Black Hawk back in 2004 when the wave of immigrants coming across was much larger than it is today, and stopping at several sites and taking a look at all that. And the term that was used, that I think wasn't used out of lack of respect, but it was the fact that drug smugglers and people smugglers are able to fit into these 785,000 people that were apprehended that year, and they're able to allow Border Patrol resources, CBP resources to be used for those efforts, as opposed to going after the smugglers and folks who have very sophisticated surveillance abilities and operational abilities to use that to their advantage. So we're on the wave of a huge opioid epidemic, if you're living in a closet and didn't know that. And as that comes forward, we do need to find ways to be able to help regulate the flow of fentanyl-produced fake oxy pills are going to be the wave, and that's going to have to do with controlling the ability of smugglers to get into the country. And so however we do that, it's important we get to it. And finally, I want to talk just a second about 287G programs. We never participated in 287G programs, but we don't have a border with Mexico. The city of Tucson does not have a border with Mexico. Pima County does have a border with Mexico. And it is one of the few counties, if you think about it, in the country that really does. They had, I think, two 287G officers that had gone through that training. And I haven't been through the training, and I suspect nobody in the room here has been. And I suspect many of you, if you're involved with immigration law, know that it is really difficult to determine who's here legally and not. And it's often the case, or sometimes the case, maybe often it's overstating it, people don't even know their own immigration status. I mean, we, honest to God, know that because of the amount of, look at what happens in the courts. There are cases where people were born to American citizens and left the country and want to come back. It's so complex. Police officers don't want to be involved in this kind of enforcement. This is a specialty. It requires, they send us to a 6-week training if you become 280G, 287G certified, and there's no way that's enough. The years of experience that people in Border Patrol and ICE get, combined with ongoing constant training, makes them experts at this. We're not experts, and we don't want to be involved in that kind of work. I mean, right now I'm commander of a task force that does narcotics enforcement throughout southern Arizona, and it has every federal agency, local agency, and everyone else in there. We work really well together, but we all have our own special skill set. And I know that DHS, and I know that ICE, and I know that Border Patrol, these folks have got real skills that we don't have in local law enforcement. We can't develop. And we, judging from the small numbers, we clearly won't have the experience over a long period of time to do an effective job at that. And then, really finally, thank you very much for giving us the opportunity to talk about it. I'm certainly, it's a topic that's very important to us. We put a lot of effort into it, and I think the motivation of police officers should be recognized, and it's maybe not to the degree that it should be, as people who really want to solve problems. This is a huge problem.
Good morning. My name is Annie Lai. I'm an assistant clinical professor of law at UC Irvine. I want to thank the University of Arizona and the Rehnquist Center for holding this event. Because others have said, it is timely and important that we have this discussion. And I'm hoping to round out the panel and complement the presentations that you've heard by focusing on the efforts by local jurisdictions, largely counties and cities, to attempt to create a bright line, or as bright a line as they reasonably can, between local policing and those law enforcement functions and federal immigration enforcement. This has certainly been the focus of a great deal of attention lately as jurisdictions that have undertaken these policies have grown. This has become a form of resistance to the new administration's plan to deport millions of immigrants, and it has brought local jurisdictions into direct clash with the administration, with the executive order on interior enforcement, and threats to withdraw funding, which build on earlier campaign promises by President Trump. I'm going to try to contextualize these efforts by drawing on the public and scholarly commentary about the growing entanglement between immigration and criminal law systems over the past 3 decades, and the implications of that entanglement. And I hope that by doing that, we will understand these efforts as a response to the merger of the immigration and criminal law systems and some of the attendant harms that have been documented. A good deal of what I'm going to say is not new, particularly the scholarship that I draw on, but I think it's important to recover that scholarship and commentary at this particular moment, and hopefully in the new context, help to generate new insights about what is happening on the ground. Now first, the merger between the criminal law and immigration systems. So I'm just going to broadly categorize some of the trends in the scholarly commentary about this merger and some aspects of it. Certainly there has been commentary on the rise of deportation as an adjunct to criminal punishment, including the substance of deportation laws that impose an array of immigration consequences for the commission of criminal offenses, both by undocumented individuals as well as legal residents. Second, there's been commentary on the increased imposition of criminal consequences for the offenses related to migration at both the federal and the state and local level. Third, now turning to a trend that has been observed that's more directly relevant to local sanctuary policies is the increasing reliance on the apparatus of the criminal justice system, including police and criminal justice system actors for interior civil immigration enforcement. And fourth, we've observed, and scholars have opined on, the incorporation of the norms and practices from criminal law enforcement into the civil immigration system without, as some have remarked, the parallel incorporation of procedural protections. Now, I'm going to broadly talk about some common examples of the merger, particularly of state and local policing functions with federal immigration enforcement. These programs will sound very familiar to some, and then I'm going to turn to some that have received less attention. So first, the Criminal Alien Program, a program that's been around since the 1980s. It's an umbrella program encompassing a range of arrangements, formal and informal, with Federal Bureau of Prisons, as well as state and local jail and prison officials for identifying, investigating, and initiating removal proceedings against non-citizens. Some examples of this include access to jail databases, the voluntary allowing of ICE officials to interview inmates in custody of state, local, or Federal Bureau of Prisons officials, or having ICE agents permanently stationed at a facility. The 287G program, which has been alluded to by the other panelists, comes from of course, the Immigration Nationality Act, Section 287G. These are voluntary arrangements whereby local officers are deputized to perform certain functions of an immigration officer. They go through the 6-week training. Beginning in 2002, we started to see these 287G agreements, although they were authorized by Congress in 1996. The federal government continued to enter into these agreements during the Obama administration, although the number of agreements began to drop steeply starting in 2009 in response to reports that they were having a significant impact on the civil rights and civil liberties of local residents. And as a result, street-level agreements, there's both street-level agreements where police officers go out in the street and they are 287G certified, as well as jail agreements where officers in the jail perform those functions. Street-level agreements ended at the end of 2005. Then there's the Secure Communities Program, which you've heard about today. It's an initiative that automatically linked civil immigration enforcement with local criminal law enforcement. It is not a voluntary thing by state and local law enforcement. Every time state and local law enforcement books somebody into a jail, that those fingerprints that are run are automatically then checked against an ICE database. And the Secure Communities Program received a great deal of criticism from criticism about the process of rolling it out and the transparency with, or lack of transparency with the federal government in its implementation to impacts on local community trust in the relationship with law enforcement. Detainers were a linchpin of the Secure Communities program, and detainers are, of course, a request that a local agency or law enforcement agency hold an individual or provide ICE with notification about release in order to facilitate transfer to federal custody at the conclusion of a state or local matter. And there's been a line of decisions since starting in 2004, bolstered by the Supreme Court's decision in Arizona, indicating that detaining somebody on an immigration detainer violates the Fourth Amendment. The criticism led the prior administration, of course, to scuttle the Secure Communities Program in favor of the Priorities Enforcement Program. That has been a decision that the Trump administration recently reversed. Now I'm going to talk about some programs that are part of this merger of local policing and jail functions with federal immigration enforcement that have received a little bit less attention. First is the joint operations. So sometimes there are task forces composed of local and federal law enforcement. Sometimes there are ad hoc operations where you have local law enforcement and ICE kind of riding along or participating on those operations. Actually, let me back up for a moment. I think it will be helpful that to just talk a little bit about why, or the benefits of attaching federal immigration enforcement functions to state and local enforcement policing functions from the perspective of the federal government. And so there's the term force multiplier, which is used to describe this notion that federal immigration enforcement can be multiplied if there is usage of state and local criminal justice bureaucracies. There are limited resources at the federal level. There's a lot of work for federal immigration enforcement agents to do. And so it makes sense that proponents of this view say to engage state and local officials. But I think there's also less obvious value from the perspective of federal immigration enforcement, which is that there may be a legitimizing function that when federal agents kind of piggyback on state and local criminal justice systems that are benefiting from the core law enforcement and public safety mission of the criminal justice system, and somehow reaping the benefits of being seen as their immigration enforcement function, being a part of that. And finally, I think that I'll talk about more later, that federal immigration agents are then able to capitalize on community members, local community members' willingness to cooperate with local law enforcement by providing information and trying to, because they're invested in the successful functioning of the local criminal justice system for various reasons. Now then, I'll turn to some of the less obvious, or at least less talked about, ways in which you see the local policing function merged with immigration enforcement. So the joint operations. So sometimes with local law enforcement and you have ICE kind of coming along on these operations, you end up with a situation like in the case of Sochi Hernandez, a longtime resident of Los Angeles who was a grandmother who was arrested last February in a joint LAPD ICE operation in East Hollywood, where ICE said, we want to come along on this operation. It was an LAPD, I think a gang task force. They went out into Ms. Hernandez's neighborhood, long story short, Ms. Hernandez ended up being arrested based on an offhand comment by a local officer, and then ICE questioning her about her immigration status and then putting her in removal proceedings. She was not charged with any crime. The only criminal history she had was a decade-old misdemeanor shoplifting conviction. Because of the offhand comment by the LAPD officer and the nature of the circumstances in which she was apprehended, she was not allowed to be released on bond unless the immigration judge set her bond at $60,000. So unless she came up with the funds to pay that. And the reason for the high bond was the allegation that she might have been involved in gang activity, even though there was no evidence of her being involved in gang activity. I think that because there was no state or local proceeding, because she was arrested in this fashion, it led the LAPD to kind of double down on the statement that she was involved in gang activity, thereby reducing the legitimacy of the gang enforcement activities. Because this became a public campaign, there was a lot of dialogue about it and questioning of LAPD's gang enforcement activities. A second example that I wanted to point out before is that starting in at the end of 2001, the federal government started to put civil administrative warrants in the NCIC database. Now, the NCIC database is something that police officers check routinely, including on traffic stops, as well as when somebody is arrested, to see if somebody has any bonds or warrants. Now, the placement of these civil administrative warrants in the NCIC database has led local officers to be confused about when something comes up as a hit, and then to detain individuals on the basis of what is effectively a civil immigration violation. Because they look so much like wants and warrants, and it's not apparent when it comes up in the computer that this is a civil immigration matter as opposed to a criminal matter. Officers have then become unwittingly involved in immigration enforcement, leading to public attention around what the officers did and criticism. The third is kind of related, which is that when ICE officers go and conduct raids, enforcement actions in the community, and they go to a home, they often come with an administrative warrant. Similarly, when ICE issues a detainer, they may come to local law enforcement with an administrative warrant. Now, essentially, it's use of a warrant and warrant, to criminal law enforcement and to community members sounds like something that allows the state to do something without somebody's consent, such as enter a home or have somebody deprived of their liberty. But these administrative warrants don't have the legal effect of judicial warrants, and so that has created confusion and criticism of local law enforcement when there's kind of confusion about roles. And then finally, an example that's gotten recent attention this week is ICE's use of ruses. In the enforcement actions that took place a couple of weeks ago, there was a case of ICE coming to the door of a woman who was also a longtime resident of Los Angeles, wearing a uniform inscribed with the letters that spell police, which is typical. And ICE told the woman that they were police conducting an investigation, and based on that, she allowed the officers to enter, and only after the officers entered her home did she realize that they were ICE agents and they were not conducting a criminal investigation. That is one of many examples cited in a letter that was sent to the to city officials yesterday, asking them to make clear with ICE that the LAPD does not want ICE to be doing this because it impedes local community trust that they're trying to build. So the harms of this kind of merger, as Juliet Stump and Dan Morales have both warned of, include that when you join a state criminal law authority with the plenary power associated with immigration law, what you do is you combine two of the most coercive and distinctly violent practices that a state can engage in, incarceration and deportation or banishment, and that we should be very careful about that as a society before doing that. But in this presentation, I want to highlight what I think are additional harms. I think it also dilutes the legitimacy of local law enforcement, and legitimacy, of course, is quite necessary for local law enforcement to do what their core function is, to obtain the cooperation of residents. Local law enforcement, for other reasons, are already facing challenges to their legitimacy, whether it's because of questions about whether they're targeting their enforcement resources at the right types of activity, or questions about the methods and tactics by which law enforcement carries out its function, and concerns about racial discrimination, etc., and civil rights violations. And so this merger between local law enforcement and ICE can create additional challenges and raise additional questions. And second, because of immigration exceptionalism, for example, civil immigration enforcement, you can interrogate somebody while they're not free to leave without Mirandizing them. It can lead to practices by line officers that ultimately lead to amount to an erosion of the procedural protections in criminal law administration, and Rehnquist has written about that, which raises additional questions and presents additional crises for legitimacy of local law enforcement. Sanctuary policies, therefore, can be seen as part of the arduous but necessary process of separating local law enforcement from immigration, enforcement, and I'll call them, in short, separation policies, or as Chris Lash has called them, disentanglement policies. These include policies that limit law enforcement inquiries and investigation into immigration status, including for crime victims and witnesses. Second, the decision not to participate in programs like 287G or joint operations that have civil immigration enforcement by ICE as a component. Third, policies that limit law enforcement action in response to ICE administrative warrants or detainer requests. And fourth, policies not to grant ICE access to individuals in custody or allow ICE to interview them without a Miranda-type warning, something like California has recently enacted into law, or not to allow ICE access to local, non-public law enforcement databases in order for ICE to carry, to kind of go through them and check for people to investigate. I think there is a meaningful difference in the discussion we've been having today between state and local authorities taking affirmative actions that impede or obstruct federal immigration law, and state and local authorities making decisions about how to use resources and saying they do not want their resources to be used for federal immigration enforcement. There's a 10th Amendment debate about that, which I won't get into, but I think that is a meaningful difference and something that helps us think through why the outcomes may be different when you're talking about questions of preemption based on the nature of the state and local action. And I just want to point out that, to conclude, that, I think you've been hearing that one reason, strong justification for why state and local officials may undertake these policies. Certainly, it's if they are concerned about Fourth Amendment violations, holding somebody on a detainer, or trying to reduce the risk of equal protection violations and Title VI violations by reducing the risk of racial profiling by their officers, even if they're not putting aside kind of state and local officers' direct responsibility or liability for civil rights violations. What they are trying to do is to restore some of the legitimacy that's lost by the entanglement of local law enforcement and immigration enforcement, and to not be a part of, to resist, but ultimately what we're describing more accurately is to not be a part of what they anticipate to be systematic violations of civil rights by federal immigration enforcement officers.
Give the panelists a couple of minutes to do maybe a round robin if you have any thoughts or want to make any connections.
I have two thoughts that one relates to secure communities and the other relates to the police. Secure Community Program is a very interesting case study of something, and it's, to my mind now, analogous to what happened in the rollout of the first Trump executive order, the one that banned people, the Muslim ban, to make a shorthand. Because when you first thought about the Secure Communities Program, and I should say I spent the last how many decades of my life fighting deportation cases, criticizing the deportation system of the United States. But I'll confess that when I first heard about secure communities, I first thought was, well, that seems okay in principle. I mean, you got people who are arrested anyway, and you have to check them anyway, you got to fingerprint them anyway, and there are federal databases. So what would be so pernicious about sharing that information in order to enhance enforcement at different levels? And I think a lot of people had that initial reaction. It seems fairly innocuous. But it turns out that if you don't think through how these things actually work in the real world, as Captain Leavitt was making clear, there are all sorts of problems that start to happen. You get false positives, you get false negatives, you get people who are not supposed to be priorities for immigration enforcement who get caught up in the system. You get people who shouldn't have been arrested in the first place who are now targeted by ICE for immigration enforcement. And I take the captain's word about the number of calls versus the number of responses by CBP here. I can say in Boston, ICE is a lot more efficient than that. I mean, if they get a call from the local police, they tend to be there. And I have experience years before this with calls from probation officers and court clerks and so forth. So there's a pretty embedded relationship there. And yet, anyway, as I said, the first thought about secure communities was it seemed okay, and I think a lot of people in the Obama administration took that position. Also part of the strategy, which I actually disagree with, of differentiating the good immigrants from the bad immigrants, but that's another conversation. But as it developed in practice, massive resistance started developing on the community level to this because of these various unforeseen consequences and sort of perverse incentives. So maybe we can talk more about it, but I just wanted to mention that. The second thing is, I really enjoy being on panels with police officers who are, articulate and caring and thoughtful and so forth about that. But I don't think that that is the model that should guide our analysis of how to protect rights. So I would be curious in knowing if Captain Leavitt happens to know about other police departments, particularly in places like Alabama and Mississippi and so forth, that I think have not done the hard work. And I certainly take your word for what's happened in Tucson, although I don't have personal knowledge of it one way or the other. I know in Boston it's still very much a work in progress, and we have seen some very nasty enforcement practices, and it's not entirely rogue officers in certain cities in Massachusetts where they're going out of their way to make traffic stops. I had a client who I encountered in Guatemala who had been driving in a car with 5 people who were pulled over by an officer, I won't say which jurisdiction, because he said they had it was obstructed driving. What they had was a little Jesus icon dangling from the rearview mirror. But I met them in Guatemala because the consequence of that was that 6 of them ended up getting deported. The one who stayed was 9 months pregnant. Now we have a separated family. The police officer who did that, I think, knew pretty well what was going to happen. So it's hard to judge, like, how do we evaluate these things. So those are just 2 thoughts.
So I got a couple of thoughts too, and to start, I'll say that there's no question there are regional differences in the way people approach problem solving at all levels. This just isn't about cops, it's about courts. It's about communities, it's about the laws they have. I mean, isn't it the whole federalism issue, Really, you got 50 different states here that have got different approaches to doing it. So I can't speak to everyone. I have seen a lot of people who see it the same way that we do. And I think a lot of major cities do because they have we are a major city, despite maybe some of the visitors here who don't realize there's a lot of people living here. I think that we have a different approach maybe than they do, and I still don't know why Omaha, Nebraska cares about what we do in the way of enforcement here in Tucson, but they do. So, I mean, I get that. I know that I don't speak for the profession in general. That's just been my experience, and I don't think, these things can spread, they can grow. I mean, this idea that it works well for us, and it works well for others is something to be considered. I'll say one thing about federal and local state task forces, and I don't think you went so far to say this, but there are times when they're very, very appropriate and important. Tucson sector of the Border Patrol has recovered more narcotics in the last 10 years, last decade, than the rest of American borders combined, all right, in the Tucson sector. Okay, so this isn't a small-scale issue with narcotics trafficking coming through Tucson. You saw Miami Vice, okay? You saw Tony Montano, remember that in Scarce? Why is it we're different? Why don't we have corrupt courts? Why don't we have corrupt prosecutors? Why don't we have corrupt police officers like they did in southern Florida? And the answer is because we work hand in glove with the widest range of different law enforcement agencies to do drug enforcement in a very efficient, effective, caring manner that is, that absolutely requires a level of cooperation. So we don't do operations with ICE for, as you described it. Did we 20 years ago? Yeah, we did, but we have not in decades. And it's because of our own experience in the community. And also, why is it that, I heard a comment about why people join task forces and all that. I'll tell you, to the federal law enforcement scheme is really difficult for them to accomplish much based on the bureaucracy within the federal system. So if they work with us in narcotics enforcement, we can get a search warrant in 30 minutes, okay? We get a search warrant in 30 minutes, and if you go through the federal system, because of the checks and balances and the bad experiences and the whatever, it can take them days to get the same search warrant, and then how fresh is the information. So we all bring something to the table. That's why it works, and that's why we do it. Very successful. And then finally, the scarce resource argument. I've made that for years. We don't want to do immigration enforcement because we can't handle all the child abuse cases we get. That's really dangerous. I'll make that argument because it's true and it's real. But the truth is, there are grants out there that have been targeting law enforcement over the last couple of decades to get us involved in this by paying for it. And they'll say, hey, go ahead and use overtime. We'll give you the overtime, federal overtime. Or the state of Arizona, could you imagine them doing that? Oh, I can. And so be really careful when we move forward about saying, well, that's the primary argument. The primary argument is an inability to work with the community to solve problems that we have together if you alienate or disenfranchise a group of people. And the secondary argument, yeah, today it is true, it's scarce resources, and that's what we go to most quickly because everyone understands that. But the other argument, I think, is much more persuasive.
I'll try to be brief because I went last, so I already had a chance to hear the other presentations. First, I do want to say, Captain Leavitt, I appreciated your articulation of the variety of audiences that law enforcement, particularly law enforcement leadership, has to speak to when crafting policies. I think, one is to the public and some of the concerns I raised about legitimacy and communication with the public, the community that you're working with. Certainly, there is direction and a conversation that you're also having with line officers and how they go about their day-to-day jobs. And then there's a variety of other audiences for policies. And so I think that's valuable when we're thinking about as advocates, what kinds of policies we're asking to be crafted and how we're working. And second, I guess just a question for Dan, because I think you're limited on time and you may not have had a chance to go into it. I'm curious to hear more about how certainly I understand detainer policies and how they are kind of in conversation with the federal system, diversion programs and post-conviction proceedings and where you're seeing the dialogue manifest.
Yeah, I can answer that briefly. I didn't have time to get into it, but the way that comes up tends to be a little bit different. So, for example, in Massachusetts and in some other states, are people familiar with Padilla versus Kentucky? I don't know. For some reason not, I guess. So let me see if I can do this really briefly. The Supreme Court decided a case that essentially said that a person who takes a plea in criminal court historically had not had a right to effective assistance of counsel to make that decision whether to take the plea based on the possibility of being deported. That was considered to be collateral to the job of a criminal defense lawyer. So the Supreme Court in a case decided in 2010 said, no, actually you could possibly vacate a conviction if it turns out that you took the plea and you were not properly advised by your lawyer. In the case of Padilla, it was a charge of transporting a fairly large amount of marijuana, as I recall. And any immigration lawyer who looked at it knew that if you take a plea to this, you are on a famous one-way ticket to Palookaville, if anybody catches that reference. But it's a fast track to deportation with no side stops. And so he took the plea, and the court said you can undo this. So then the question came up, is that retroactive? What about people who took pleas before 2010? Well, it turns out there's some state variation on this for reasons I can't get into. It's quite interesting to read, for example, the decision of the Massachusetts Supreme Judicial Court, which said the Supreme Court concluded that for federal purposes it was not going to be retroactive, but in Massachusetts it is going to be retroactive because of deeply entrenched constitutional traditions in our state relating to retroactivity and fairness and various other things. And so then the question is, will federal authorities respect that or not? And there's been a similar history in what is the definition of a conviction. In Massachusetts, we have something called a continuance without a finding, that a judge sentences somebody to and then says, don't worry, you have no conviction in Massachusetts. You can go take whatever job you want. You can answer any form, no, I don't have a conviction. However, for immigration purposes, that's considered to be a conviction. So you have these overlaps, and this ends up being federal-state conflicts about how we interpret the decisions of the state. So that's one example. And it comes up in a number of different arenas, and I think will continue to come up. The California 364-day one is going to be ripe for challenge. Are the federal authorities going to respect that or not? And so sooner or later, a federal court has to sort that out.
Okay, let's open it up for questions.
Captain Leavitt, you had mentioned a couple of times before that in the 1980s, you cooperated with ICE in these joint raids or joint ventures, but today you're not. What has changed in terms of either the law or socially or the community? What's the difference between 1980 and today?
The very same thing that changed our reasonable suspicion for stopping people. I mean, we've evolved, and we understand what kind of damage it does to the community to be involved in that kind of enforcement. And I'm not besmirching the character of the ICE agents. These are good people, and they're given a very, very difficult job, but we figured out that this is the kind of thing that makes it difficult to establish trust relationships in the community, just as we have many other issues. That's what the change is. And so over a long period of time, we've evolved, and we hopefully are getting better and better at it all the time. And I think it has a lot to do with the changes in the hiring that we do over the years. When I look at how these groundswells occur, we hire really good people today. I mean, I certainly wouldn't make the cut today. I mean, it's amazing the people that we hire, and it's the next generation will save us from ourselves, I'm convinced. So, I mean, that's the difference. The difference is just evolution.
What kind of people are being hired? Is it better education? Is it?
The constant rant you always hear about the next generation that's been going on since the beginning of people, it's just not true. These people are so much more qualified to exercise discretion and so much more global and better human beings, I think, that we're going to be saved by them. I really do.
Yeah, hand in the back. Yes.
Yeah. Could I ask you to speak to maybe the perspective of, from the other side of an ICE agent who, I mean, I'm hearing all the time from them, and this might be crocodile tears, it might be, but I'm hearing from them that they feel very hijacked by everybody else wanting to get into the act, that they feel like people are grabbing low-hanging fruit, and they came to work with a list of fugitives and absconders and drug dealers and terrorists and whatever they're supposed to be going after, and they are being hijacked by other agendas, police and other federal agencies rounding up low-hanging fruit and bringing them to them and making it so they're duty-bound to process them, and that becomes a resource issue for them, the ICE agents.
Well, so I do work a lot with ICE agents today in my current responsibility, and I'll say this, you know, we all, in all of our expertise that we develop individually in our own little silos or organizations, we cover that, and we like to know that we're the pros, we know how to do this. And it really is insulting, I think, when you take a patrol cop, or even me, after years of experience, and we give you 6 weeks of training, and now you know as much as an ICE agent does. Well, it spits in their face. I mean, it really does. This is a craft, and it has to be practiced every single day. Short story, I was coming through the border many years ago with my in-laws, who were primarily Spanish speakers, and my wife and my kids, and we go through, and I've done this a long time. I'm pretty good at picking out who might be here illegally, and you develop an ability or without documents, you develop an ability to spot that. Well, they do too. And when we're walking through, I watch the guy, he sees my mother-in-law go through, speak only Spanish, my father-in-law, doesn't stop him, my wife, my kids, and he gets to me and he stops me. And he did it with a smile, and he was doing it for a reason. I mean, they're good at this. They're really good at this. And they make mistakes. But they're really good at it, and it's insulting to presume that in 6 weeks, voila, I'm an expert. So I see that.
I have to say that I'm not sure I fully understood the question in terms of what ICE agents think constitutes overburdening them or hijacking their workload, but the last time I checked, the federal budget for immigration enforcement was over $18 billion. My experience that every time I've looked at every level is that there's more money than the feds know what to do with for enforcement purposes. So I never experienced the idea of a real resource shortage. I can take the turf pride issue, which is always an issue in law enforcement, But the resource problem, I don't think is there, although I suspect we're going to see still more money devoted to immigration enforcement. And by the way, the idea that the Trump administration can hire 10,000 ICE agents on short notice, it ought to be very worrying because of everything Captain Leavitt has been saying. I fully agree. The complexity of immigration law is legendary. Many of us have gotten, made careers on this, not to mention tenure and various other things. And it just is not getting any simpler.
Well, so we had 500 Border Patrol agents in Tucson when I became a cop, and we had 500 patrol officers in the city of Tucson. Now, or 500 patrol or police officers. Now we have 900 police officers in the city of Tucson and 3,500 Border Patrol officers. And I used to hunt down the border and all that, and the few times I go down there now, there's a lot of people, a lot of guys out there. So.
Hand in the middle.
I just want to say that I do believe that discretion can often be exercised favorably. But I guess this sort of notion of things evolving and ground up and people's, well-meaning officers' experience rising to the top, why doesn't that seem to be happening north of the Gila, where we have a sheriff who basically is under federal indictment, I think, or certainly contempt of court. So, some of it is environment. How do we enforce that kind of environment?
Well, I say this, it's been difficult. I know that we started going down the race path, and maybe you'll remember this, Annie. The Tucson Police Department is the only department in the state to sign a proclamation against racial profiling. No other chief would do it. And so when we did that in 1998, that was 3-4 years later, suddenly everyone goes, well, yeah, we've always been on board. And so hopefully, by setting an example, it helps. But what complicates that is Tucson is a very demonstration-friendly community. And because we're a demonstration-friendly community, there's a lot of demonstrations. And other chiefs around the state, and I hear I'm a member of a couple of different organizations where a lot of commanders get together, and they look at what happens to us and go, thank God it's not in my community. When the community holds a forum to deal with immigration issues, only one police department shows up in southern Arizona. That's us. And guess what? Who gets attacked? And what do they see? They see that. Now, I'm not complaining. I'm just saying that, so it's a long, slow process to evangelize again this whole idea. It can happen. I'm not saying it'll happen normally. It may need some top-down help. Maybe that's true. But I have hope that, again, by the way, they have a new sheriff. By the way, the new sheriff in Maricopa County. And the first thing he did is he eliminated a bunch of these immigration homes. So things are changing up there as well.
But actually, one thing I wanted to mention that I did mention regarding Sally Hernandez, some of you may know this, what's happening in Austin now is that there's state legislation that's being proposed, and my sources tell me is extremely likely to pass, that will deprive local law enforcement at the county level or at the municipal level from exercising their discretion in the way that she is doing vis-a-vis detainers. So there's going to be political battles at the state level, and I fully expect Arizona will be one of those places where you may see that kind of pressure. I don't know if you know more about that than I do, but we're seeing it in a number of states already.
Can I just add briefly, with respect to the former sheriff of Maricopa County, and I had the chance to, as in my capacity as being involved on the legal team in that case, observe training that the federal court ordered to be rolled out based on the finding of systematic racial profiling for amendment violations. That there, in every department, I think it's different. A great deal of modeling and signaling from the top of that agency is what I think caused a number of the problems. And you saw officers who were not particularly happy with what their leader, the predicament their leader had put them in communities where they were trying to do good work.
We talked earlier beforehand about how they can require all sorts of things, but cops are smart, and even if it's a top-down direction, eventually they'll do things like not ask the right questions to develop reasonable suspicion. That's how it works. And that's why, really, Do you really think we only found 7 people here that were here without documentation in the last 4 months in the city of Tucson? 100,000 contacts we have a month. Do you think we only found 7 people? Well, there's 7 people that left, all right? I'm just saying, reasonable suspicion didn't make it, they didn't get there.
Can I ask a follow-up question? It's actually really useful.
Be careful.
It's very useful and refreshing to actually hear statistics that you've been able to give us. So if I remember right, there were 7 people that were ultimately supported, but there were 160 calls.
189, the last 4 months, 189. Now, to be clear, if they're being booked into the jail, that's Cooper County's problem. They have an issue with. I mean, honestly, we don't get involved in the immigration issues. They're being booked into the jail. So this is a field release situation where we encounter them in the field and we write a ticket, and then we, if we had reasonable suspicion
Right,
at
so
that
if
point,
reasonable
we make the
suspicion
call.
develops, you have to.
Apparently, we didn't develop it that often. So, I mean,
You developed
189 times to make the phone call, and they managed to make it out to the stop in 7 of those times. And why is it true in Boston, why is it true everywhere else? Well, this is a target-rich environment for ICE. They don't have to drive around the streets of Tucson and find people. There's plenty of
Somebody's
other
supporting
work.
400,000 people a year.
Yeah, there's plenty of other work for them to do, and so in the city, they're very actually respectful of the situation that we find ourselves.
Do you anticipate, though, that proportion of calls to which ICE responds may rise over time?
I think the issue really is that we've created, I think, some real improvements into our internal procedures as well, where we're requiring enough documentation to make this not the path of least resistance to call ICE. So we require a significant amount of paperwork to make that phone call to ICE.
Okay, it's not here in front of us.
So when states want to dissent from federal action, they can dissent from the inside and they can dissent from the outside. So by dissenting by the outside, we're talking about states and localities having a zone of either sovereignty, in the lighter cake version, where they have a measure of autonomy, not necessarily sovereignty, they have autonomy to just take decisions on their own. And so in either of those cases, states could be dissenting through sanctuary cities or otherwise against federal action. But another way that states can dissent is from within, which is like the idea of kind of Hurricane and just imposing. And the idea there is that by being part of the system, that states could actually shape it from inside, and that it's a valuable way for states to shape federal policy on the ground. And so I'm wondering, hearing these narratives, which sort of sometimes intersect and sometimes at odds, I'm hearing that state and local officials do not, as a general matter, certainly enforce law in a discriminatory way. I'm hearing that federal officials are at least as apt to enforce the law in a discriminatory way. So my question is, why don't these sanctuary cities sign on to these 287G and enforce the law in a way that will respect rights, and that can keep an eye on ICE officials from within and say, not from the outside, saying, look what they're doing, and that the state and city officials, we're working hand in hand in task force and side by side, and we're seeing what the federal officials are doing, and they're doing it in a way that's discriminatory. And by the way, us states were not. So they could actually take the case. Why isn't that being talked about?
Well, I appreciate the comment. I think it makes me think further. And I think one thing to keep in mind is that we're likely to see federal enforcement carried out in a manner that feels much more indiscriminate than we have been seeing. Not that people didn't get caught up, that we might think shouldn't be caught up, but that given what the enforcement priorities now are under the new administration, it's just hard to see how there's going to be rational targeting. And so one reason a state and local or local jurisdiction may want to get involved is that they can, to some extent, exercise some front-end control. Maybe that's too strong a word, over who is brought to the attention of federal immigration enforcement agents. I think it's for each jurisdiction it's different, and there are a number of competing considerations, right? And so maybe there is the thinking, that you mentioned, but that's got to be balanced against what is then the impact on other policing functions, what is then the city's relationship on other matters like health, access to health services, and whether people feel comfortable enrolling in health programs, et cetera. So I just think that may be a consideration, but it's one that, state and local jurisdictions are balancing so many considerations, and, what the outcome is, I think is going to be different for each jurisdiction.
Yeah, I think that's right. I mean, the term sanctuary city, even when taken on sort of purely legal level, as you of course know, has so many different meanings. There's so many different vectors and points of contact that can be manipulated, sometimes overtly, sometimes subtly, but it also operates on a rhetorical level to make a sort of political general statement about a particular jurisdiction's feeling about federal enforcement writ large. And so there's a voice function here too. So if you're asking, why don't we go to the San Francisco Board of Supervisors and say, hey, if you really cared about immigration, why don't you cooperate with the feds? Is that the question? I think the answer to that would be, we have to cooperate with the feds in a million ways already. But we're trying to make a point about the places in which we do not want to as energetically cooperate with the feds as we have been doing. We're trying to draw those lines. So I think by the very nature of the denomination, it's not, there's no scenario in which any municipality would say we're not cooperating in general. So sanctuary city means different things. And it also depends a lot on which state you happen to be in, because the overlapping functions of state law, anti-discrimination law, and various other things make a huge difference.
So my question might follow a little bit on the one David just asked, but from a different direction. A couple days after the election, the mayor of Philadelphia said, we don't want to be known as a sanctuary city anymore, we want to be known as a Fourth Amendment city. And he was touching on, I think, something that you already alluded to, that there's a policy argument for disentanglement, that we just don't want to have our police operating in conjunction with ICE. But there's also been a great deal of litigation. I think most recent district court cases in the Dallas Federal District Court. I don't know how the Texas legislation will interact with this, but essentially all these cases at the district court level essentially saying it might not really be an option to follow some aspects of ICE policy because of the problems that Andrew discussed in terms of that one ICE warrant is not, but it's not what we normally think of as a judicially warrant. And I think from this, there might be two different types of sanctuary style legislation coming about. One might simply say, under no circumstances will we cooperate with ICE. There's another, which I think might actually address what David suggested in terms of establishing kind of dialogue between localities and states and the federal government, where a state might say, it's not that we can't cooperate with ICE, but if ICE wants our cooperation, they're going to have to check a few boxes, like show us. And ICE right now does not have the infrastructure to actually comply with that. And so in the short run, it looks safe, the two approaches. But the actual policy on paper is actually an invitation to ICE from the state, maybe prodding them to improve their operations.
I agree with that completely. And also in the detainer context, there is a non-trivial, real risk that you could get sued for a lot of money if you're a jurisdiction that holds on to somebody just because an ICE agent says, please hold on to this person. You can certainly envision 1983, and there have been already. And so there are big judgments, and if the clip continues, Sally Harris talks about that, that's going to fall on the locality. So I think you're absolutely right about that. The Fourth Amendment designation of the city of Philadelphia is quite remarkable for those of us who watched the evolution of the Philadelphia Police Department, but I will say that that's in the... Now, yeah, I'm going back to Frank Rizzo. But that is a very nice way to put it in terms of detainers, but it doesn't get at all the other sense. So that's always sort of disaggregating the sanctuary designation.
So I hear the sounds of lunch coming from over here, so I please join me in thanking the panelists.
So
will actually be served on the rooftop deck. If you go out the doors at the back of the room, the resort staff will direct you up the stairs. There's also an elevator, and there will be